Okay, picture this. A friend buys you a bottle of ginger beer. It's one of those dark, opaque bottles, you know the kind, so you really can't see what's inside. So you drink some of it. Tastes fine. But then your friend pours out the rest. And that's when you see it. The decomposing remains of a snail. Yeah, you get sick, of course. Shock, stomach illness, the whole deal. And believe it or not, this one gross moment, it would go on to change the world. So that bizarre but totally true story comes from a famous case back in 1932, Donoghue v. Stevenson. And this case, it literally created the modern law of negligence. You know, that invisible set of rules that governs everything from your doctor's decisions to how people drive. So the big question is, how on earth did a snail in a bottle create a legal principle that affects every single one of us today? Let's unpack it. Right, so for the woman who drank it, Maid Donoghue, there was a huge problem. She didn't actually buy the drink. Her friend did. And back then, no contract with the seller meant no way to sue. Her case was basically a dead end unless she could find a whole new way to argue it. So her case goes all the way to the highest court, and it ends up creating a brand new test for negligence. To win a claim like this, you now have to clear 3 hurdles. There's duty of care, breach of duty, and finally, causation of harm. Now, for this explainer, we're going to focus on those first 2 because that's where the really game-changing ideas are. All right, first hurdle, duty of care. This is the big one. Before you can be blamed for being careless, the law has to ask a fundamental question. Did you even have a responsibility to be careful towards that person in the first place? I mean, think about it. Did the ginger beer maker, Mr. Stevenson, owe anything to Mrs. Donoghue, a random customer he'd never even met? And this is where the judge, Lord Atkin, came up with something totally revolutionary. He called it the neighbor principle. It's this one simple idea, right here in this quote, that created a general duty for all of us to be careful. But it also raised a huge new question. Who, in the eyes of the law, is actually my neighbor? And no, we're not talking about the person who lives next door. Your legal neighbor is anyone who's so closely and directly affected by what you do that you really ought to be thinking about them. So the guy who made the ginger beer, he couldn't see Mrs. Donoghue, of course not. But he should have known that someone, a consumer, was eventually going to drink it. And that connection, that's what creates a legal relationship. Now, as you can probably guess, the law doesn't just sit still. For decades after this case, courts have been tweaking and refining this whole idea. They were worried that this neighbor principle was maybe a little too broad, that it would open the floodgates to all sorts of lawsuits. So what we've seen is this constant push and pull, a real balancing act between making sure victims get justice and, keeping the whole legal system from grinding to a halt. Okay, so let's say a duty of care is established. A driver owes a duty to a pedestrian. That's a given. Now we hit hurdle number 2. How do we actually decide if our driver broke their duty? Well, the law's answer is this really fascinating idea, the reasonable person test. What this means is that we use an objective standard. The court doesn't actually care what you were thinking or if you were having a bad day or even what your skill level is. Nope. It compares what you did to what a hypothetical, reasonably competent person would have done. The old-fashioned term was the man on the Clapham omnibus, but today you could just think of it as the average person on the subway. And this is a really crucial distinction. See, a subjective test would ask something like, did you try your best? But the objective test that negligence law uses asks a totally different question. Did what you do meet a reasonable external standard? It's this objective approach that makes sure everyone, no matter who they are, is held to the same fundamental standard of safety. And the law can be brutally strict about this. There's a famous case where a learner driver was held to the exact same standard as a fully qualified, experienced driver. The judge's words were unforgettable. His incompetent best is not good enough. Wow. And it's the same for a junior doctor. They're judged not as a trainee, but by the standard of the job they're doing, because at the end of the day, the public is entitled to a certain level of safety. So how do courts figure out what this reasonable person would have actually done? It's not just a guess. They do this very careful balancing act, where they weigh a few key factors to decide if what the person did was, in fact, unreasonable. And to get to what's reasonable, the court looks at four main things. First, how likely was it that someone would get hurt? Second, how bad could that injury be? Third, how easy or costly would it have been to prevent it? And finally, what was the social value of what the person was doing? Let's see how this plays out with some real examples. First up, how likely was the harm? Let's take a cricket ground as an example. Is the club being negligent if they don't build a giant fence around it? Well, like with most things in law, it depends. So in one real case, a cricket ball was hit out of the park and injured someone. But get this, in the club's entire history, over almost 30 years, a ball had only been hit out of the ground 6 times. The court said, look, that risk is so incredibly small, so remote, that the club wasn't negligent. A reasonable person just doesn't prepare for something that unlikely. But now contrast that with another cricket club, where 8 or 9 balls were flying out of the ground every single season. In that case, the court said the risk was obvious and pretty significant. Failing to do something about it? That was a clear breach of their duty. So you see, it's the same basic situation, but a totally different likelihood of harm leads to a completely different result. Okay, next question in the balancing act. How severe could the harm be? Because it makes sense, right? The more serious the potential injury, the more care a reasonable person is expected to take to prevent it. A perfect example of this is a case about a mechanic who was already blind in one eye. His employer knew this, but didn't make him wear safety goggles. One day, a piece of metal flew into his good eye and he was left completely blind. Now, the risk of that happening on any given day was pretty small. But, and this is the key part, the consequence of that small risk for this particular man wasn't just an eye injury. It was catastrophic, total blindness. Because the potential harm was so severe, the employer had a much higher duty to protect him. So after all that, why does this matter? Why should you care? Because these ideas, born from a snail in a bottle and fine-tuned over a century, they're like a hidden social contract that we all operate under, every single day. Every time you get behind the wheel of a car, or a company designs a product you buy, or your local council maintains a park, these 2 core questions are right there in the background. First, did I have a responsibility to be careful toward this person? And second, was I careful enough? When you really boil it down, the law of negligence is just society's way of saying, hey, none of us are islands. Our actions affect other people, sometimes in big ways. And because of that, we all share this fundamental responsibility to think about those consequences and just take reasonable care. But this whole thing leaves us with a really tricky final question. When the law holds a learner driver or a junior doctor to the standard of a qualified expert, it's making a choice. It's prioritizing public safety over that individual's inexperience. And that is a tough, tough line to draw. So is this strict, objective standard really the fairest way to balance the needs of everyone involved?